meeting for March 30th, 2023. Everybody rise for the pledge of allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Being a special meeting, there is just one item on our agenda this evening, which is the Blue Sky Towers amendment to site plan and special use permit. The applicant seeks an amendment to a previously approved site plan and special use permit application concerning a wireless communication facility located off Creek Road. And this is Blue Skies Towers 3 LLC is the applicant. Normally, we, during our meetings, we review the minutes of the past meeting, but we're going to forego those until our next regular meeting. So we'll get right through the agenda.
We're going to plug in the applicant's attorney,
Yes.
Jared Ross.
Hi, Andy.
Hello, Jared. How are you?
Good. I'm watching on YouTube Live. I hope I'm not caught with feedback.
No, actually,
So far now, we're going off of Polycom to try to keep the feedback low. Just, Jared, if I could just have you talk, I'm going to take a look at my monitoring and see what you're coming back in on the microphone. So please tell us about your vacation.
He's not listening to me.
All right. I'm hearing it twice. I'm going to log off to YouTube.
Yeah.
Oh, can you hear me now still?
Yes, we can.
Okay, great. It's too confusing with my ADD anyway, for to have two different conversations that are the same thing, but about 10 seconds delayed watching it on YouTube. So yes, my vacations, it's both work and vacation, so I have been able to play a few rounds of golf, but still working. But I am, within 50 feet of a pool deck at this point, so I hope you're all that jealous. But other than that, I'm still working.
Well, that's great, Jared. I'm picking you up good, so we'll start it with the meat of the meeting.
Good evening, everyone, and I appreciate your accommodation of me calling in by phone for the application. I know I appeared at the last meeting and discussed the application for the eligible facilities request. I do know that following that meeting, there was a request from Planning Board Attorney Gilchrist for some additional information. That information was regarding the history of AT&T's involvement. That information was provided to Mr. Gilchrist via email on April 17th, and again to the current secretary thereafter. So I believe that's where we are procedurally in terms of the request for additional information and our response. With that, the application, the request remains the same, except for the 6409 eligible facilities request extension of the tower of the 20 feet position of 9 antennas and 15 remote radio head units.
Okay. I think I will turn the floor over to Andy at this point. He's going to go over the particulars of this application for the benefit of the board at this point.
Yep, I will update the board. So as you recall, as Mr. Lusk explained at the last meeting, we were reviewing the application. It is one under the federal law, under the Spectrum Act, for an eligible facilities request to add 20 feet to the existing tower. One thing that the federal law does allow the local board to do is review the application to determine whether it is in fact an eligible facilities request. And we've been reviewing the application documents and the record on the tower to determine that. I've coordinated with Planning Board Engineer Bonesteel and with Chairman Oster on that. Mr. Lusk was correct that there was a request for some additional information, and that information's been provided by the applicant. So I do want to remind the board, or at least review with the board, that, as Mr. Lusk explained, it's an application under federal law, under the Federal Spectrum Act. 6409 is the section at issue. And what that provides is that a local government board, here the planning board, must approve an eligible facilities request for modification of an existing tower. Jared, you still with us?
Yeah.
Okay. Must approve the request for the modification of an existing tower that does not substantially change the physical dimensions of the tower. And federal law does provide that an increase of height of 20 feet, as this application requests, is not considered a substantial change to the physical dimensions of the tower. Another element here is that the modification being proposed does not defeat the concealment element that was a condition of the original tower approval. If you recall, this tower was required to be a stealth monopine. The application does seek to extend 20 feet, but to include the branches and to try to continue to make the facility appear to be a pine tree. And the FCC regulations and guidance provided does indicate that as long as the proposed modification does continue to provide for the stealth or the concealment element by continuing to have it appear as a tree, that is not, or does not defeat the concealment element. The mere increase in height alone does not defeat the concealment element. And guidance also provides that even if the extension goes above or exceeds above an existing tree line, that's not does not result in a defeated concealment element. So really the key here was to determine whether this application constitutes an eligible facilities request. And we wanted to make sure that we fully understood the application documents. They are complete. Okay? You do have the application in front of you under the cover letter of Nixon Peabody with exhibit tabs A through M. It is a complete application. However, one of the tabs was the tower sublease between AT&T and Blue Sky Towers. And that was included at tab F. And quite frankly, Wayne and I reviewed that. It's a 26-page document. And what was provided in the application documents was 15 of those pages. You can bear with me for a minute. Stay corrected. So the tower sublease provided was a 26-page document. Only 15 pages were provided. What had not been included in those materials were the exhibits or the schedules to the sublease. And that's what, on behalf of the planning board, we requested from the applicant. in writing through an email that those additional pages to the sublease be provided. And the applicant did provide those. And we've had a chance to review them. And I think it's important for the board to step through the approval record for this tower, because it is relevant, we think, to whether this constitutes an eligible facilities request. So what I've given you, and I have provided the documents to Mr. Lusk as well this afternoon, and I just wanted to step through with you what we've determined to be some relevant parts of the record. I give you kind of a preview that this really is a review of the prior application, particularly with respect to AT&T. The current application is to extend the tower by an additional 20 feet in height to accommodate AT&T. But as the board will recall, AT&T had been part of the prior review. So there are some documents here that I think are relevant for the board's consideration on the current matter. So the first document I provided to you goes all the way back to March of 2019. And these initial documents were included in the record concerning the underlying tower approval. I'll indicate when we get to the documents on the current application for the eligible facilities request. So this first document was from AT&T addressed to the town, and it did indicate that they had an intent to locate on this proposed tower. This was obviously 2 years prior to the tower approval, but it was the letter of intent to indicate AT&T didn't want to locate on the tower. The next document is a document from Young Summer LLC, who was the attorneys for the applicants during the underlying review. And it is their response to the public hearing comments on the tower. And that came in June 8th of 2020, or at least it was dated June 8th, 2020. What I want you to do is go to the next page, which was page 7 of this response to comments. And focus, if you would, on comment 21. Comment 21 was, will the 80-foot tower accommodate a third carrier in addition to the Verizon and AT&T? And the response from the applicant was, it is expected that the 80-foot location, if selected by the town, would be built as a stealth monopine tree, which will require an ornamental cap of approximately 15 feet. As we know, ultimately, the ornamental cap was 5 feet. At the antenna center lines available, it is likely that it will only hold the 2 carriers. So the response to the comments there indicated that the proposal was for the 80-foot plus the ornamental cap with the 2 carriers, AT&T and Verizon. The next document is, once the public hearing comments were reviewed and once this board, in conjunction with the zoning board, determined that the 80-foot tower height location was the preferred alternative. You recall there were 3 alternatives, one at 85 feet, one at 150 feet, and one at 240 feet. The board determined that the preferred alternative was the 85-foot tower height. The applicants submitted updated plans. So the next document you have is the plan of the tower. This is the proposed 85-foot tower. It is dated September 18, 2020, revised tower location, and this was the location of the tower at 85 feet. And you'll note that this plan does show the Verizon antennas at 76 feet and the AT&T antennas at 66 feet. And it does provide the antenna orientation for both Verizon and AT&T. Next, there was also an updated environmental assessment form prepared after the preferred alternative was identified. I've given you 3 pages out of the updated EAF. Pages 1, 4, and 13 of part 1 of the updated EAF. We look at page 1 first. There is a box for a brief description of the proposed action. And in here, the applicant stated Blue Sky Towers 3 LLC and Cellco Partnership, DBA Verizon Wireless, and AT&T, paren, the applicants, and paren. And below, it does indicate, in general, the installation will consist of the following: an 85-foot tall monopine tower, Verizon and AT&T antennas installed on said tower. So on this document, it is identifying AT&T as an applicant. Page 4 of 13 of the updated EAF does describe the action as, and this is in section, it would appear to be D1G. And here, one structure is being proposed. The dimensions of the largest proposed structure is 85-foot tower. And then the last page, this is dated October 12th, 2020. So after this preferred alternative location was selected, there were updated plans and an updated environmental assessment form submitted by the applicants, and AT&T was identified as an applicant. Once that was submitted, the boards continued, and that included the Zoning Board of Appeals, and this board continued the project review. A secret determination was made. The zoning board acted on its variance applications, and this board did ultimately approve the special use permit and site plan in March of 2021. And that's part of the record as well. Now, the next document in the packet you'll see is a letter from the town building department dated March 16th, 2022. This is only the first page of the letter, but this was approximately a year ago. At that point, Aerosmith Development was the applicant representative requesting the additional 20 feet. That was the first time the application came in. And last year, on March 16th, 2022, there was this letter of incompleteness, which, quite frankly, Wayne and I worked with the building department on sending out. This was a multi-page letter. I've just given you the first to give you a context of the timeline. Now, as I indicated, the planning board's approval was March of 21, and thereafter, while I don't have this in the packet, the building permit was issued by the building department. The tower was constructed and completed, and once that happened, this initial request about a year ago came in for the additional 20 feet. That was not pursued at the time, as we know. As I've explained and as Jared explained, as part of our current review, now I'm getting into the documents pertaining to the current application for the additional 20 feet, the eligible facilities request under federal law. We did ask the applicant to submit the balance of the sub-tower lease agreement, the missing pages, which were the attachments to the lease. And those documents were provided by the applicant. And I've attached 2 of them, and I think this completes the timeline for the board's discussion and consideration. The first document is what's identified as a co-location application, Blue Sky Towers form. There's a few dates on here that are, we think, relevant for the board's consideration. So if you look at the very top box, which is labeled co-location, installation type anchor co-location, there is a submittal date on this. And bear with me because this is small type. I will grant you. But there is a submittal date on this document of April 19th, 2021. It's approximately a month after the board did approve the special use permit and site plan for this tower. This, by the way, is the application form submitted by AT&T into Blue Sky Towers to co-locate on the tower. So the submittal date listed by AT&T is April 19th, 2021. The next part I'd like you to focus on is there's a box here on tower information. It's in the top third of the document. And within that box, there is a spot for structure height. Does anyone not see that? It is small type.
80 foot plus 20
Right
foot.
here.
It's about, yep, it's about a third of the page down, okay? Now, again, to refocus, this is AT&T prepared the application to submit to Blue Sky Towers, okay? And they dated it April 19th, 2021, a month after this board approved the tower at 85 feet. In the structure height, it's listed 80 feet plus 20-foot extension. So this was prepared by, it appears to have been prepared by AT&T within a month or so of this board's approval of an 85-foot tower, and AT&T is identifying, or appears to identify the tower height as 80 feet plus 20-foot extension. And the next thing I want you to focus on is there's a section on really the technical information. You'll see in bold the areas called Sector 1, Sector 2, Sector 3, and Sector 4. You see that? Okay. Along the left side, there is an item for, it's fourth one down, tower mounting height. And if you can see that, that's listed as 95 feet. So this record would appear to have been prepared by AT&T about a month after the tower height of 85 feet was approved by this board, indicating that AT&T's identifying the tower as 80 feet plus 20-foot extension and proposing to locate the panels at 95 feet. And the last document is a document that amounts to an updated plan, at least for purposes of attachment to the tower sublease, which itself is dated October of 21. And this is a plan showing the tower at 105 feet. It's the 85 foot plus the 20 feet extension. And in this, it does identify the proposed AT&T antenna center line at 95 feet, but does locate the existing Verizon panels. So we thought this was information that we should bring to the board. The timeline clearly shows that after the preferred site selection at 85 feet was made, the application documents previously in front of you on the underlying review were updated to show the tower at 85 feet with Verizon and AT&T on the tower, with AT&T being identified at 66 feet. An updated environmental assessment form provided that continues to identify the tower at 85 feet and identifies AT&T as an applicant. And the board continued and completed its project review and approved the tower at 85 feet. And then what appears to be an application document prepared by AT&T about a month later, identifying the tower height at 80 feet plus 20-foot extension, ultimately leading to a revised plan showing the 105-foot tower with the antennas for AT&T at 95 feet. clearly, if the board can review and discuss that record, I think it's important, we think it's important that we make sure that the earlier action that the board took on approving the tower was based on correct, complete information. And in that regard, the board can consider, if it wants to, request any additional information from AT&T as to when the determination was made not to locate at 66 feet. AT&T was identified as an applicant, and I think to complete the fact record in front of the board, again, this is within the board's determination. I'm going to give you one more point of legal review on this in a moment, but if the board views that information as to what AT&T's intentions were, plans were, prior to the board's approval and then after the board's approval, then you can certainly ask for that information. That this was not a Blue Sky Towers issue. It's clearly an AT&T, but AT&T had been identified in the underlying application documents as an applicant. The one legal point I wanted to go over with you is under the current application, under 6409 of the Federal Spectrum Act and the FCC regulations, that they're very clear that once that application is received, the board can do a review for completeness, and within 30 days of the submittal date can request additional information to determine whether it's an eligible facilities request. Mr. Lusk at the last meeting was correct in saying that the information you can ask for, though, is only bearing on whether it's an eligible facilities. And that's a limited factors under the federal law. But the board did ask for that information within that 30-day period through my office, through my email. And the applicant did respond to that. The federal guidance, the FCC regs and guidance go on to say that if that for that matter, the statute says if the applicant has responded completely to the request for the additional information, that ends the inquiry, that ends the request for any additional information. In other words, you can't use this opportunity to keep asking for more information to extend the timeline, the shot clock. We did ask for the balance of the documents constituting the tower sublease, and the applicant did provide those to us. So there has been technical compliance with that provision of the statute and the federal guidelines. It just may be that the information that was provided responsive to that request itself leads to more questions. That's not provided for the federal statute or in the guidance documents. Doesn't mean you can't ask for that information from the applicant, nor does it mean the applicant can't provide that to you. I'm just telling you that technically under the law, there's really no basis for the request nor a requirement that the applicant respond. Now, again, we view this as information to determine whether this is an eligible facilities request. The applicant can view that differently, but really what we're looking for is making sure that the underlying approval was in fact based on a complete and accurate record. And the issue really is AT&T, and if it did not alter its proposal until after the board approved the tower, then that's an important piece of information for you. If AT&T determined prior to the board's action approving the tower that it was not going to locate at 66 feet, and it did not provide that information to the board despite the pending application documents, that's a piece of information for you to consider too. So we're at the point now of having gone through the record. You can discuss that. You may want to consider a request for some additional information from AT&T through the current applicant. But that's really up to you. We just want to make sure that the board did have complete and accurate information prior to the prior approval. And then lastly, the 60-day clock in which to act on this application still applies. And the only extension on that thus far is the limited number of days between our request for that additional information and when that was supplied by the applicant. It was just a few days. So in order to meet the 60-day clock, which now technically would run until sometime in early May, you really have your 2 meetings in April. Certainly the board could consider scheduling a public hearing tonight, but it's also within your discretion to say, we'd like to see that additional information before you schedule the public hearing. If you chose to do that, my recommendation would be procedurally to put the matter on the agenda for your meeting next week. And if you're inclined to schedule the public hearing at next week's meeting, it still could be held the second meeting in April. And the reason for that is in the ordinary course, as you know, the town's official newspaper is a weekly, and it does give us a little timing problem on getting public hearings scheduled at a next meeting, a 2-week interval. But given the application of the federal law and the requirements for timely processing of these applications in the federal law, this would, I think, be a situation where the board could consider using the town's alternate official newspaper, and that's the Record, and that is a daily. So in this case, we could. In the ordinary course with routine applications, the official newspaper, News Press, should be used. But given the application of federal law and the time requirements under the federal law for these types of applications, this would be one where I think the town, or the planning board, could utilize the alternate newspaper and the Record, and we could still hold a public hearing at the second April meeting. So, Wayne, I hate to ask you this, but do you have anything to add in all of that? I've gone on for too long.
No, I would just reiterate that we need to look at whether or not the application constitutes an eligible facility. Keep that in mind in the discussion. We can't ask for RF data. We can't ask for anything that isn't relevant to determining whether it's an eligible facility.
Yes, and I would concur with that. And those factors really are, is this an existing tower? Is this a proposed location? Does the application substantially change the physical dimensions? And does it otherwise defeat the concealment element? And I went over with you earlier that a 20-foot extension is deemed under the statute not to be a substantial change in the physical dimensions of the tower. And as long as the attempt is made to continue the branches on the extension so that it continues to attempt to appear to be a pine tree, that under the regulations and the guidance of the FCC, that does not defeat the concealment element. Doesn't affect the stealth monopine condition.
Can we go back to the first condition, existing tower? Does that mean existing tower approved for 2 co-locators? Does that have?
The statute-
I couldn't hear that question, Andy. Could you repeat the question, please?
Sure.
We're going to let the board member repeat her question.
I'm sorry, I couldn't hear it.
The eligible facility guidance, that option 1, existing tower, does that speak to whether or not it's an existing tower approved with co-locators? Is there a definition of existing tower in the 6409 statute?
There is. The term existing is defined, and that's a tower that was reviewed and approved by the local municipal review board.
Let me, can I ask a question, Andy, on this, the timeline that we're actually looking for is from AT&T.
Correct.
When originally they decided to be at 66 feet, and I think it's important to find out from AT&T why they changed and when they changed their decision to have to be at 85 feet or 86 feet. I'm not sure exactly the additional height. Because it seems to me like they agreed initially to the 66-foot location, and somewhere along the line, that location was not adequate for their service, and they chose to go higher, or request to go higher. I think it's important to figure out where that request was, as far as a timeline. And if it was significantly before the approval of that 85-foot tower, I think that's critical to the application.
It could be viewed as a relevant factor. It's at least a fact that the board can ask for in the record. And that, again, I'm going to repeat. You can certainly request that information. I don't think it's inappropriate, but I'm not sure it's under the federal statutes required to be provided. I just think it's information to complete the record, because this was a very recent review and approval of the tower. Construction of the tower was only recent as well. And to get that complete information on that timeline in connection with the prior review and approval of the tower and the current request as eligible facilities, it's information for the board to request, and it's up to the applicant to determine whether to supply it to you.
Well, just an additional comment. If they, in fact, according to this, basically needed that 85 feet, say a month after the approval, there was no shovel in the ground by then. There was no starting a construction. And I'm just questioning why we did this now instead of immediately applying for an amendment to it right after it was approved. Is that a reasonable question to ask?
It's
Well, let's put it this way. It's probably a reasonable question to ask, but is it relevant to this one?
Andy, if I could be heard.
I was going to suggest that that's it. Initial should be responded to by the applicant. So go ahead.
I agree in terms of the factual record that Andy had indicated, so I don't want to reiterate that, but I think it's also important I think in many ways we answered the questions regarding the timing. In my email back to Andy on St. Patrick's Day at 10:04 a.m., I was forwarding an email from Elizabeth Thompson, the general counsel of Blue Sky. And she was reiterating some of the facts. She provided me the information that Andy had requested on behalf of the board. Let me just read it, and I hope you can hear me. It says, included, she said, please be attached, and those are the documents that were requested. She also stated our original application was filed in May of 2019, proposing a 150-foot monopole with Verizon at 146 feet above ground level. In November of 2019, Blue Sky and AT&T signed a tower sublease agreement with Exhibit 2, was provided, depicting AT&T at 136 on the 150-foot tower. It was not until August of 2020 that the planning board of Blue Sky finally settled on the current height and location of the tower. Until that time, there were 3 different heights and locations proposed on the property, 80, 120, and 150. Originally, AT&T confirmed that a height of 66 feet would work for an 80-foot monopile proposal, but ultimately they redacted that confirmation and stated that it would not satisfy the coverage needs. That was before the approval. That's me adding color commentary. That's not what she said because I found that out today. Nothing more was executed with AT&T until after the site was approved. The Verizon as our anchor tenant, we were focused on constructing the tower and installing Verizon. The site was approved on March 15, 2021. I understand that AT&T was still shown on that 66-foot location on the construction drawing. That was the latest agreed upon location. While they had expressed that it would not work, we being Blue Sky, continued to be hopeful that it would. In October of 2021, 7 months after the approval, it was confirmed with a revised lease exhibit that AT&T needed additional height to satisfy their coverage needs. So while AT&T submitted the application to Blue Sky, nothing happened until October of 2021 when they confirmed the coverage needs and were dealing with the issues. At the time, the lease exhibit from the November 2019 sublease with AT&T was replaced with an exhibit showing the current proposal of 95, requiring a tower extension to accommodate their needs. There was no effort on the part of Blue Sky or AT&T to mislead the town. AT&T's coverage needs were not solidified until after the approval, at which time it became clear that an extension would be necessary. Please let us know if you have any questions. I think that information was provided in the email exchange back to Andy to provide some clarity on the facts and the timing. From our perspective, I believe we've answered the question with regard to the timing and the sublease. None of the sublease or anything was amended until after the final location, et cetera, and they submitted their application and Blue Sky processed their revised application. We have no intent to deceive. I think everybody was hopeful that the 66 feet would work from Blue Sky's perspective as a tower owner and a real estate vendor, that would work. But I think, again, to the chair's point, I think we've answered the question. I think we answered the question when I believe from a legal perspective, strictly legal perspective, we were not necessarily obligated to do that because the questions don't question whether or not we meet the eligible facility standards as outlined in the application and in the federal law. We provide that good faith and effort to provide your information. Blue Sky was focusing on getting the tower delivered for Verizon, and that had hoped that the AT&T and Tennis Center line would still be valid. And AT&T's plans were not, can change over time, and they weren't solidified until the 95-foot application was submitted and eventually approved in the fall of 2021.
Okay.
And I'll just note, Jared, I appreciate you going through the email. I did not provide that to you, given that you were forwarded something from in-house counsel, general counsel at Blue Sky. I will make that full email chain available with board members.
I think it answers a lot of the questions. There's no intent to deceive by anyone. I think we were trying to figure out where the tower was going to be approved and what height to determine what the next steps would be.
Well, I don't disagree, Jared, that email does indicate no intent to deceive on the part of Blue Sky Towers, your client. And I'm not suggesting an intent to deceive by any party, but hearing from AT&T as the chairman said, if I can use the phrase, what it knew and when it knew it, whether that's provided or not, that's up to the applicant. But We just know, we just note that material was prepared by AT&T with a date of April of 2021.
I'm sorry, the application you mean for the COLO?
Yes, yep.
I can state that, I did have a conversation with the AT&T representative this afternoon.
Yep.
And again, I wasn't there, the project manager wasn't there at that time, again, we're reviewing records. But again, AT&T, made a decision during it's our understanding that they made a decision internally at some point before the approval, of the tower that they didn't think 66 feet was gonna work for them. But there's nothing final on, for that. The only co-location application that we had in was the 136. We did not yet have a final location and tower height for the Verizon anchor tower. And so there were too many things in flux for anyone to lock in anyone, because the only application that AT&T had submitted was the 136, and everybody was waiting for all the stake in the ground about location, et cetera, to be able to deal with it. And everyone was hopeful. Again, Blue Sky is in the real estate business. They wanted to make sure, hope that AT&T would be able to host AT&T at that tower at the agreed upon height. But they've indicated AT&T, and I'll state it for the record, that it was before the approval that they determined that the approval of the tower, that they determined that 66 feet would likely not work for them. And so again, I there's a secondary issue. I'm not sure it's relevant, because under in any regard, because it doesn't deal with the the eligible facility request standards in the first instance, but secondly, even if AT&T was on at 66 feet, they could apply to add 20 feet for more antennas if they wanted, or a third party. So I just don't see how it's relevant to the overall issue before you. Again, but I believe we've answered the question in good faith, trying to work with the town, as you know that we have.
Okay, thank you. Does anybody have any questions?
Well, one thing for the board to consider then, now that that fact timeline has been confirmed on the record, you may choose to schedule a public hearing, and if you want to do that this evening, it would still need to be the second meeting in April. You can choose to consider the information you've heard tonight and schedule it at your meeting next week. It's really, at this point, procedurally up to the board.
So we haven't gotten that information in hand that was just relayed to us by the applicant. Is that correct? There's an email out there that,
Well, I have it.
okay,
I did not distribute the email, I just distribute the documents.
okay.
I will now distribute the email to you, the one that Jared read to you on the record, so you'll have that. If you'd like to get it and review it and put this on your agenda next week, that's fine. We'll still meet the timeframes for the federal 60-day shot clock.
Does anyone, let me just hold does anybody think that information is critical to have at this point, as far as scheduling a meeting for them at our first meeting? Or should we just go ahead and schedule a public hearing? Any opinions on that?
I would say just go ahead and schedule a public hearing.
I agree.
That's agreed.
I'm sorry, I couldn't hear it.
The general consensus of the board informally right now is to just go ahead and schedule the public hearing for the second meeting in April. That would have to be our timeline on that. Just go ahead and schedule it. I have a tendency to, as chair, agree with that. Andy, is that something that we have to do a proposal for?
You know, you just schedule a public hearing on this application for then your second meeting in April.
So that'll be April 20th.
Okay, and
April 27 PM.
7 PM. Did you hear that for April 20th? At 7 PM?
That sounds good to me.
7 PM?
That's fine.
And I don't think it's necessary for you to be on our agenda for our next meeting, which is April 6th. We'll just see you at the public hearing.
That's great. 7 PM, we'll see you then, and enjoy the rest of the week. I appreciate everyone's time. Any other questions before I sign off?
I just want to confirm, Jared, that you're doing the mailing list? This is Chuck.
I think I provided the mailing list with our application. It's included in the application site plan. There's a list of right.
That's great. You're going to mail to them, right?
Oh, I didn't know that was what you wanted me to do.
Right, Jared, on this one, on the underlying application, I know the applicant did do the mailings for the public hearing and provided proof of mailing.
Again, I think okay. Does anybody have
Well, we don't have a public hearing notice prepared yet, so that's an issue. Jared, I'll coordinate with you on that, okay, so that we make sure the public hearing is timely noticed.
All right, so the mailing, you're gonna take care of the newspaper advertisement? Is that
Correct.
what I'm saying?
Correct.
All right, you provide me with the notice, we'll arrange for the mailing. Do you have did you confirm the mailing list is what you want, or I'm happy to do the mailing itself.
Chuck? I have no list. I believe that the area is higher, the notice area is higher for a tower than it is for our standard 300 foot.
Okay, that's fine. Jared, you and I will have to review that. I'll pull out the mailing list from the underlying. I think I have a copy of that.
All right,
Thank you.
Okay,
thank you, folks.
before you go, is there any other questions from the board? Any questions from our resident engineer?
I have no questions.
I think we're all set, Jared.
All right, I'll see you on April 20th, God willing, for you and for me.
All right. Okay, see you then. Thank you for attending the meeting.
I appreciate the special meeting and accommodating my ability to be there. Thank you. Have a great night.
You too. Good night. Okay, that concludes our agenda. Can I just review our agenda for meeting 6? I have Brad,
Public hearing at 7.
that's a public hearing at 7 o'clock. That's for a minor subdivision. Rao, waiver of subdivision. And number 3 is Gardner, special use permit. And I assume everybody got materials on that. I received mine tonight. I know no other items on the list.
What was the second one?
Rao, waiver of subdivision.
14 Ridge Road.
Am I missing anything, Andy? Anybody?
Well, the only thing is Henry was here tonight. I'm not sure he's on the agenda. We did send out a letter to all the parties in that litigation to notice them that Riser had made the application for the lot line adjustment. As
And
far as I know, we've not received anything from any of those parties. I'll coordinate, I'll confer with John on that.
is there a timeline on that, 30 days?
I don't, as I sit here right now, I don't know that. I'll coordinate with John on this.
So tentatively, he could be on our agenda also.
Right now, a tentative, confirm with John.
Okay. And then, okay, duly noted. And obviously on the 20th is the public hearing for Blue Sky. So I don't know of anything else at this point that's on there.
I have, one gentleman may come in for just for initial,
New business?
new business for car sales on Hewitt Drive.
Okay.
Hewitt Lane, yeah,
Is there anything else?
business light over there, you can do it.
And I will adjourn the special meeting. Do I have a second?
Second.
All those in favor?
Aye.
Any opposed? Thank you.
There's two Hewitt's, right? There's Hewitt Road and Hewitt Lane.
Yeah, that one was off of Brick Church. The one off